Committee on Children and Seniors. Our first item of business is approval of minutes. You've received minutes from February 15th, 16th, and 17th. Does anybody have any additions or corrections? Representative Neighbor.
Thank you, Madam Chair. I move adoption of the minutes for the 16th, 15th, 16th, and 17th.
Okay. Moved by Representative Neighbor. Second by Representative Hoy. To approve the minutes, all in favor say aye.
Aye.
Opposed, no. I forgot to offer some discussion time. I don't see any discussion after the fact. Okay, so we're going to hear two bills here today. I'll open the hearing on House Bill 2468, enacting the Kansas Foster Youth Bill of Rights, and ask Jesse to give us an explanation.
Thank you, Madam Chair. I'm Jesse with the Reviser of Statutes Office, and this briefing is on House Bill 2468. So the two bills today have very eerily close numbers. So the first one is always going to be the children one, the youth one. So 2468 is enacting the Kansas Foster Youth Bill of Rights. So House Bill 2468 proposes that there be a Kansas Foster Youth Bill of Rights to be placed in what we normally talk about as the SYNC code, the revised Kansas Code for Care of Children, and that such Bill of Rights be consistent with the policy of the state when it comes to the SYNC code. And that policy the state is expressed in KSA 382201. And so this new section proposes a list of items that a foster youth shall either have the right to or is referencing something that the foster youth already has a right to in statute. The proposed Bill of Rights then includes a list of the rights that the youth would have, and those include to live in a safe and comfortable placement, be treated with respect with siblings, possibly, and if proper, with a relative or someone from the child's community, to visit with family, to have as few placements as possible, to have and maintain belongings, and to make a list of those belongings, provide that list to a case manager, and to be able to bring those items with them when placed out of home in a transportable manner, have access to appropriate school supplies, services, extracurricular opportunities, and other activities, and to attend school daily. The right to receive a diploma, high school diploma, if the credits are earned by the student or by the youth. Be notified of all hearings that are occurring in regards to their case, as well as attend pursuant to the code. And some of these are limited in as far as the child having the age of or being developmentally able to when it comes to their participation or attendance in those hearings. To have a guardian ad litem represent the best interests of the child, and to have regular contact with the child as well. To request a lawyer who will tell the court what the child wants, if different than the determinations of the guardian ad litem. So at some point in the current statutes, if the guardian ad litem and the child, there is a disagreement, they do have the right to be able to ask the court to appoint another attorney. The right to have privacy, to be able to send and receive unopened mail, to make and receive phone calls privately as well, to have regular and private contact with and access to their case managers, to the attorneys that are appointed to them, including the guardian ad litem, and other advocates that may be in the child's life, access to accurate and necessary information for such child's well-being from the case managers and the guardians and any person who is by law liable to maintain, care for, or support the child, the right to have as few changes in case managers as possible, the ability to contact a case manager supervisor if there happens to be a conflict between the child and the case manager that cannot be resolved between the two of them. And lastly, when transitioning out of the child welfare system, they have the right to be an active participant in developing that transition plan, having all the services and benefits of an independent living services be explained, access to a bank account, learning how to manage money, learn job skills appropriate for the child's age, and to be involved in life skills, training, and activities that would help them in that transition out of the child welfare system. And this would be a part of and supplemental to the SYNC code, as mentioned before, and would be called the Kansas Foster Youth Bill of Rights in statute.
Okay, thank you. Committee, are there questions for Jesse? Representative Wagner.
Jesse, thank you very much for the explanation. I do have a question. What is the I mean, all these things are arguably good policy, but what the differential having it shall have the right to, does that like trump other things, or well, is there any, I guess one question as far as the import of that, and then secondarily, are there other places in statute where we say like, you know, people on welfare have the right to, or people in public schools have the right to, or, you know, where it's laid out in the structure of rights?
Right. Thank you, Representative, for the question. So it's kind of like a varying degree of that when you think about it. So, for example, when you look in the list and it says in accordance with KSA something, 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 then that's something that already exists. And by referencing in the accordance of, it's not trumping that existing law. That's the law that says this shall happen, this should happen. When it comes to items that don't have an accordance with KSA or don't have a statutory reference, that's something that is possibly already in policy or in regulation or somewhere else, but is not specifically an item in the SYNC code. So that's where those statutory references really are. So if, for example, there is nowhere in statute or regulations or anywhere that says that a child shall make a list of belongings to have when they're placed out of home, then now this then would make that a requirement at some point for the department or the case managers to make sure that that is occurring.
And there's no differential whether the child is 5 years old or 17 years old. I mean, it's just regardless of their age. Correct.
So there's no age limit in regards to all of them. When it comes to certain ones, they may specify when age or developmentally proper or appropriate.
Okay. Thank you.
Further questions? Okay, thanks, Jesse. Okay, we'll open the proponents and start off first with Representative Gail Finney. And welcome to committee. It's so great to see you, Gail.
Chairman Concanon and members of the committee, thank you. I really appreciate this. For some of you who don't know, I've been a foster parent for 8 years. And one of the reasons that I got into foster care is because when I first became a legislator back in 2009, foster care issues was like number 1 or 2 complaints from my constituents. They were always complaining about foster care, whether it's the foster care parent or foster youth or someone affiliated with foster care. And so the reason for this particular bill and at this particular time is recently, last fall, I had a foster youth in my home that was fighting not to go back to an abusive home. And so she wanted to have a word with the judge or someone so that they would be aware of what her voice was. And so she had tried calling her guardian ad litem, and I tried calling her guardian ad litem. We didn't get any response. I tried calling her caseworker, called the case supervisor, and nobody was aware that there was a foster youth bill of rights. And so what I did, I started doing a Google search because I'm like, this child should be able to have some type of voice on her placement. She's 17 years old. She's almost at the age where she'll be aging out of foster care. And so I just kind of got a little upset. And so when I was told by a supervisor that, anyway, we found out about court, not from the case supervisor or the case manager, but she found out about it from her therapist, that she was going to be having court within a few days, and she had no idea about this. And so once she found that out, we went to work and started researching, and like I said, we reached out to as many people as possible, and nobody knew anything about this. And how I found out was through a Google search, that there were like 21 other states that had foster care bill of rights, and Kansas actually had one in their policies. And so finally what ended up happening, I ended up contacting her case supervisor and told her, and I texted her a copy of those Bill of Rights and said she has the right to speak for herself in court or be able to provide testimony or say something. And so the lady actually told me, she said, well, she's not supposed to be there. And if you bring her, the court is going to be upset with you and they probably would admonish you. And I said, well, you know what? I'm not even worried about it. So I took the young lady, I took her out of school. We went to court and her guardian ad litem walked in and when it was right, almost time to be heard. And she yelled out his name and he looked at her and he says, I'm busy. I don't have time to talk to you. And of course, me being myself, I got really PO'd. I chased him down the hall and I told him, I said, sir, you have a youth here that would like to have a word with you. You're her guardian ad litem and you need to speak to her as soon as possible. So he said, okay, and he took a couple minutes and he spoke to her and I had her prepare her statement ahead of time, which was 2 pages front and back. And she gave it to him and he got a chance to read it and he shared it with the judge. And long story short, it worked in her favor that she didn't have to go back to that home. But most foster youth, they do not have someone to stand up and fight for them or that's not afraid to speak up on their behalf. And I'm sure she is not the only one. The day we went to court, the court was packed. There probably was 50, 60 people there, and she was the only kid in the whole building. This is a shame that our youth do not know that they even have bills of rights. And it's a shame that they don't even have the opportunity to have someone to listen to them. That guardian ad litem completely ignored her. And one of the things I didn't have a chance to do, I had planned on introducing a bill about the guardian ad litem, that we need to have more responsibility and accountability there. But I ended up having surgery, so I didn't get a chance to introduce that one. But that's something maybe this committee can look at later. Because the guardian ad litem, if they're the ones who hold the key to those notifications. This kid didn't receive a notification. And if it doesn't come from the guardian ad litem sharing it with someone, they don't know. And if they don't know, it doesn't do them any good. So, but I don't want to stay on that, but I just want to emphasize that we have this Bills of Rights already in our policy, and it's been there since 2012, and it was actually created by the Kansas Youth Advisory Committee, I can't remember, but it stands for KAYAK, and those youth, they developed it, and DCF accepted it. So if it's good for our policies, it should be able to be good for our statutes, and I think that would make it much more visible, accountable, and transparent. So I'm hoping that this committee would take that into consideration, that if we can put it in our policy, surely we can be able to put it in our statutes to make sure that these children have some say about their lives. I wasn't going to mention this until the reviser started talking about the kids and their clothing. Like I said, I've been doing this for 8 years, and I probably have had maybe, 20 plus children, because I usually just do it when the session is out. But I can only recall one time that a kid had a decent pair of shoes. Because it's just like standard. I know when a child comes to me, I'm going to have to go out and buy them shoes. I'm going to have to go out and buy them clothes. And Kansas should be better than that. Our kids should be able to have their belongings, follow them, be able to have not just a bag, a black bag that travels with. People say, in our statutes it says that they have a suitcase. They don't have a suitcase. Very rarely do you see a suitcase. It's usually a black trash bag that they bring whatever they have with them. And a lot of times they are, I hate to say we're raggedy, but they're not very nice clothes. And like I said, shoes, I wish I had an organization that did nothing but donate shoes to foster care kids in Kansas, because our kids are being deprived. And a lot of it comes from not having accountability. And so we really need to work on that. But I want to close and say that, if this law, if this Bills of Rights are good enough for our policies, please make it good enough to be a part of our statutes as well. So I'll close on that, and thank you for this opportunity. I'll accept any questions whenever you like from me.
I think we'll take questions now.
Okay.
I'll just comment that in the, I think it was the Special Committee for foster care oversight that we had, that you mentioned that about the shoes. That had never occurred to me before, and I really appreciate your experience with that and sharing that. But that created a lot of discussion about shoes and what an issue that really is. They often come with some clothes, but no shoes. Yeah, okay.
Raggedy shoes.
Yeah. Do we have questions for Representative Finney? Representative Owsley.
Not a question so much. Thank you for being here, Representative. Thank you, Madam Chair. I'm glad that you brought up the trash bag instead of a suitcase, because when I did a day in the life of a foster kid, you know, that's what they gave us. They gave us a trash bag and said, put all your belongings in here that you can. And I've recently heard of a drive to take old luggage that, you know, was going to be tossed out and get it to foster kids. So there are initiatives out there, but I've never heard of one for the shoes. But thank you for being here, and thank you for bringing this to our attention. Thank you, Madam Chair.
Representative Smith.
Thank you, Madam Chair. Again, just a comment. Growing up in Atchison, we had a receiving home where the kids from BIS, the Boys Industrial School, which no longer is would come and live. And when they came to the high school, a lot of my classmates, they'd have new clothes and they'd have new shoes, but there was something missing. Mm-hmm. They wanted to be loved, and that wasn't there. So I appreciate you being a foster parent, and what these kids really want is a place at the table. They want to be where they're welcome. Our representative from Wichita makes a good point of that. Mm. I appreciate you being here. Thank you.
Thank you.
Further questions? Representative Wagoner.
Yes. No, thank you, Representative Finney. I really appreciate your testimony and also just your example of taking in foster kids. I do have a question about, I know in past years, you know, we've heard an awful lot about problems with the foster care system, and like when you came here in 09 or 010, but has it not gotten better? I mean, what's your experience, you know, from where you've been on that?
Well, to be quite honest, I've been a part of several organizations. I shouldn't say organizations, just groups of people, of foster parents that try to get together and they kind of complain about what foster care does or doesn't do or they should do. And I haven't really heard a decrease in that. I think it got to the point that people felt hopeless, that there was really nothing that they could do about it. And, you know, now that we've started talking about these Bill of Rights, it's giving people a little more hope, I think, that, you know, at least maybe my voice can make a difference or we can make a change. But you may hear a testimony. I'm not sure if she's going to provide a positive testimony. I mean, not positive, but provide a testimony regarding a youth that was killed in Wichita by the name of Cedric Lofton, how some of those people in those organizations think that if we had had this Bill of Rights, that it probably could have helped the foster care parent before it got to the point where the kid went to the juvenile intake, juvenile intake. It's like a little, I don't want to say jail, but it's a place where they take youth that are having issues. And they were saying that if we could have had this in law, maybe the foster parents would have been, you know, been able to know that they could have different actions that they could have taken ahead of time. So, but to answer your question overall, I think those same issues are there. And I just think people have got to the point that, you know, they kind of felt hopeless after a while.
Further questions? Okay,
Right,
thank you.
very much.
Okay, next up we have Rachel Marsh with Children's Alliance of Kansas. Welcome back, Rachel.
Thank you very much, Madam Chairwoman, Vice Chair Esau, Ranking Minority Member Owsley, and members of the committee. My name is Rachel Marsh. I'm with the Children's Alliance of Kansas, and I want to offer our support for HB 2468. It took a lot of self-regulation for me not to write a treatise on the history of child's rights and how they don't have very many rights as a matter of law in our history. I will save you and spare you that and only offer that putting something in statute would be a significant step forward for the ability of children to be protected with a certain standard of care. One of the things that I do when I look at proposals and bills that are coming before this committee is I look at whether the bills are consistent with our existing law, so that we're not creating inconsistencies or confusion, because we don't need to add that into our child welfare system. And so one of the major reasons that I can stand very much supporting of this bill is that the very first line, the consistent with the policy of the state in KSA 382201, because that means that we have to look to what we're doing, and we haven't created inconsistencies there. And I don't see that there are pieces in the bill that would create a challenge in that area. So that's something that I think is important. What I do want to offer is just a couple areas that we might consider tweaking the bill. One is related to mail and phone calls. When we have children who enter care because of being survivors of human trafficking or being runaways who have connections with folks that we're trying to protect them from, sometimes it will be difficult to get a court hearing that would immediately prevent contact with people who might be a safety risk. And so I would ask that this committee consider an amendment related to making sure that we put within the best interest of the child within, I believe it's section 13. The other piece, we think that is there because that's what the entire code stands for, is the best interest of the child under 382201. But I would hate for a case manager in the future to feel like they had to put a child at risk for emotional challenges or even physical challenges in terms of unregulated contact. The second thing is that there is some mention in here related to relatives, but there is not mention related to kinship families and what we call fictive kin. And I'll give an example in my own life. I'm sure you all have that, where I have an Aunt Bonnie who is definitely not my aunt, has no relation to me in any way. But if my children were to ever enter into the foster care system, Aunt Bonnie better be able to be visiting for my children's benefit. So I would want to ask that we consider the kinship and the fictive kin and the close relationships as well in the bill. And finally, Representative Finney and I discussed this bill, and she told the story about how frustrating it was to try to track down the guardian ad litem. And I was looking at how could we improve that beyond saying you have the right to a guardian ad litem, how could we actually make that have some teeth? And one of the things that I thought of is I went to look at the way that a child has the right to get an attorney to represent their wishes instead of just have a guardian ad litem. And a child can ask for an attorney if their guardian ad litem has, at a certain age, you might have a difference of opinion with your guardian ad litem about what's best for you. And so the child can ask a guardian ad litem to please represent my wishes. And if they're so distinct, the judge can order an attorney for the child for good cause shown. So I would ask this committee to consider whether we would want to put into statute that good cause might equal the inability to stay in consistent and regular contact with a guardian ad litem. And so that a child, if they felt frustrated that their voice wasn't being heard, could have an attorney that maybe would give them another opportunity to have that. So those are my detailed thoughts on the generally good concept of building a known and clear statement of rights that children can have and can expect, and then can help them know when they can advocate for themselves, when they can bring a voice. The standard of care in child welfare over the past number of years has really embraced the concept of youth voice, using youth engagement and youth being able to be an important part of the developing of their case plan in their own lives. And so we stand in support of the bill. Thank you.
Thanks, Rachel. Committee, do we have questions for Rachel? Representative Wagoner.
No, thank you, Rachel, for the testimony. And since apparently you know a lot about children's rights and such, and there's apparently 21 other states who have done this, is there a track record where this goes as far as, as far as having it called rights, as far as it does something different to the system than just having it as sort of good policy for, KDHE or whoever?
Actually, thank you for that question. I think it's a really important question. If something like this bill would pass in its current form, how it is stated, it would be, what I see is it as a statement in one piece of law that we could hand to a youth in foster care and say, this is a summary of your rights as consistent with existing law. because otherwise they have to get out the entire child in needed care code book and find every time it mentions the child themselves and figure out what is applicable. So I don't think it is, except for in these very specific ways, such as, and I have the copy of the bill in front of me, there are some specific things that aren't mentioned in the statute that would become very clear. But to the extent it's already in the statute, or in accordance with a piece of the current statute, it really would just be providing that information in one coherent bill.
Further questions? Okay, thank you. And next up, we have Mike Fonkert with Kansas Appleseed. Hi, Mike, welcome back.
Thank you, Chair Concanon and members of the committee. I am Mike Fonkert, Campaign Director with Kansas Appleseed Center for Law and Justice, and I come today to you in support of House Bill 2468. I will keep my comments relatively short today. I've been in front of the committee before, and we've talked about the ongoing needs of the foster care system, to just kind of highlight what has happened over the last decade. Have things gotten better? Have things gotten worse? While DCF has certainly made some strides in certain areas, other areas that we track, such as average length of stay in foster care, is now up over 23 months, which is the highest it's been since 2010. So while some things have gotten better, others have not, and much has stayed the same. We strongly support this bill as it represents to us a very important starting point for another conversation about accountability for DCF and for the folks that we trust to care for our foster youth. I think two things I'd like to highlight for the committee, maybe more than two. We'll start. This does represent really a taking of what exists in many ways in policy and putting it in statute. I think that alone is a important step to have all of that information in one spot, and also an important step in terms of showing how significant these rights are, how important they are, putting them in statute. We do have concerns, though, that many of these rights that are found in various policies aren't necessarily being respected as we would like. And so we would encourage the committee to consider including some sort of mechanism around accountability, enforcement. What does a child do and what happens if these rights are violated? I think that would be a way to really substantially strengthen this bill. Additionally, we've done some research around the other states that have these bills, and a very important part of legislation like this is making sure that kids, parents, and folks in the system are aware. And so while it would be nice to have this all in one spot in the statute for people to be able to reference, it would also be, in our opinion, a really positive step to include notification provisions. So, for example, it would obviously be up to the will of the committee, but something like when a child enters care, they are presented with these Bill of Rights, they are talked to about them, and then there's some sort of documentation that they acknowledge that they have been made aware. If that child is in care for a significant length of time, as we've seen, we've got kids in care for 23 months more, they should be made aware more than once that these rights exist, because we've heard about belongings not following, different records not following kids. We would want to make sure that this is more than just a symbolic gesture to enshrine policy in statute, and make sure that there's enforceability mechanisms in it, and that the kids are absolutely aware of the rights they have and know of what they're to do if they feel like their rights have been violated. So really support the concept. I think this is certainly a step forward for the state, but would encourage the committee to work on those concepts, hopefully to strengthen this bill. And I'll be back to talk about the next one as well. And before I wrap up, I know I was in front of this committee last week, and there were some questions about data, and you may have noticed I did not follow up with any data, and that's because the 2 data points that were requested from us are not publicly available, disaggregated by race. And so that doesn't mean that DCF doesn't have that data, but we do not. So thank you for the opportunity, and happy to answer questions at the appropriate time.
That would be right now. Thank you. I had a question, but it's gone. Representative Vaughn.
Thank you, Madam Chair. Thank you for your testimony. I was wondering, do you have any recommendations for what the accountability or enforcement provision might look like, or how that could potentially be amended into this to give it a little more teeth?
Yeah, I think there are a few ways to go. I think as a bare minimum, my idea would be enumerated steps for a child to take or for a concerned guardian to take if a child's rights have been violated. Some sort of clear path to report a violation of their rights. As far as what other accountability tools would be appropriate, I think, something there to make sure all of the adults in our system that are supposed to be upholding these rights are held to that. I don't necessarily have a specific in mind, but between all of the folks with the contracting agencies, DCF, and all of you all, I think we can come up with some concepts that increase accountability.
Great, thank you. Thank you, Madam Chair.
Thank you. And I've been thinking about this too. I think that with the interest of this bill, that if we could have the opportunity to move forward with it, that we might set that part aside and maybe address that more with the Foster Care Oversight Committee or Child Welfare Oversight Committee to have some more time for discussion of, because I've been thinking that, if we hand them a piece of paper, it's going to get wrinkled all up in that trash bag, and so if we give them something, it probably should be laminated so that it stands the test of time, and if they lose it, they can get another one. And
Digital, physical,
yeah, yep. So other questions? Representative Penn.
Thank you, Madam Chair. Representative Vaughn stole my question. I know, right? Thank you so much for your testimony here today, sir. I wanted to ask a quick question on the heels of both of those. Right now, this is basically to collect all of the disparate rights that are out there somewhere in the ether, codify it, put it into one collected source. Correlation to that, are there, like you said, are there already those types of accountability or enforcement tools out there in the ether that we need to corral together as well?
I think does
that exist?
That's a great question. I would want to say yes. If we searched the code, there would be some pieces that we could pull related to accountability. I haven't done that myself, so I can't say for certain. But I would want to believe that in that code there are discussions of accountability at various places that might be able to be pulled together for that reason.
And Madam Chair, if I may, do you see, and I'm devil's advocate on this one right here, a child in care comes in with the foster parent and says, hey, I have my stuff laminated or I have the quick access on my phone, and you can't do whatever it is. Basically, they're in charge and shut down the authority chain in the house. Do you see any threat to the authority chain that the foster parent provides with said enforcement?
That's an interesting question. I mean, that doesn't appear to us to be a large concern. I think there would likely be some disagreements about, between a child and a parent about, just like there are in every household, I'm sure, about what was right and what was not. But having them clearly stated, if that child does feel like their rights have been violated, and there is a clear way for that to be reported, then somebody could mediate that situation, ideally. So,
Further questions? Representative Vaughn.
Thank you, Madam Chair. Just more of a comment to follow up. if it was the will of the committee to separate kind of the enforcement versus the Bill of Rights, I know we talked about Senate Bill 12 too, and the performance-based contracts, so maybe that's something that could be part of that process as well, just as a thought. Thank you.
Representative Esau.
So I apologize that my question might be for more than one proponent. To follow up on what one of the representatives said about the whole parents saying these are the boundaries and the child saying, but no, that violates my rights to be able to do whatever. One of the conferees brought up, Rachel Marsh, I believe, brought up the concern about someone who might be controlling a child abusively. She didn't state it exactly like that, but with phone calls or mail that the foster care family couldn't see. We don't know what's really going on there. And I don't know if any of you that are proponents of this might have an idea of how that part could be either addressed or that we make sure that we word it carefully so we're not opening up that child to still being controlled by somebody who's abusive through phone calls and mail, even though I totally understand the privacy and the right to be able to do those things. I mean, what teenager doesn't want to be able to talk to their friends, you know?
So I don't feel like I have the expertise to answer that question with any depth and would certainly invite previous proponents to address that. But I think one thing that stood out in the previous testimony was there was a recommendation around tweaking that language to make sure we're not putting kids at risk. So I would imagine Ms. Marsh has some more thoughts on that as well.
Any other questions? Representative Wagner.
Thank you, Madam Chairman. Somewhat following on what Representative Penn said, the word says where such child lives in the least restrictive environment. I mean, you know, that seems very, I would say, subject to interpretation, but also as far as, I mean, parent A is going to have sort of a notion of what's appropriate versus parent B. I mean, obviously there's sort of extremes, but as far as least restrictive, how would you interpret that? And don't you think that's going to be a real, you know, between parents and just a foster kid, I have my rights, you know, my curfew is midnight, it's not 10 o'clock, you know.
Yeah, I mean, there again, I feel like that tension is going to be tension that's present in most child, caregiver relationships. And so I would want to first look at that particular provision and see if that's pulled from current policy now or if that's one of the relatively new languages. If it's pulled directly from policy now, obviously we're already navigating that in a variety of ways. And so I would be less concerned. If it is a brand new provision, I think that concern gets a little bit stronger, and I would encourage the committee to thoroughly vet that idea.
Other questions? Okay, thank you. Rachel, did you have anything else you wanted to address on the previous question from Representative Penn?
Thank you. There was two questions I actually wanted to respond to, and now I can't remember the one that was from Representative Penn.
Please, yeah.
So sorry, didn't mean to speak out of turn. Number one, from Mr. Franker, he was talking about there being concerns that the current laws don't have accountability and enforcement. Were those things already out there? Do we corral them together right now? And the other piece is, how do we address that power struggle that happens between the children and the parents? Yeah.
So I think that's an excellent question, and I think Mr. Franker raises an important point. As a licensed attorney, I think one of my frustrations is that accountability should be happening in our courtroom. Guardian ad litem should be representing their clients. And if that's not happening, I think we have a larger problem. Apparently, somebody agrees. If I might also respond to Representative Wagner's questions about least restrictive environment, I think that's a really important question. I'm glad that you caught it. Those of us who are in child welfare know that least restrictive environment means a specific thing. It means that you don't have a child in a group home with nobody locks on the doors, but with lots of restrictions if they could be placed in a group home with fewer restrictions. And you don't have them in a group home with some restrictions if they can be in a family foster home. But I think Representative Wagner raises one of those points that we need to consider, that just because it's language that we use casually doesn't mean it won't create some challenges in how it's interpreted if it's not vetted from that statutory perspective. So that's why I think we do need to be real cautious about vetting the bill in terms of each piece of language, because even I missed that one. That could create an argument for a child that you can't tell me what to do, and that's a challenge.
Representative Penn.
Not for you, Ms. Marsh. Madam Chair, may I ask a question of Representative Finney?
Sure.
Yeah. Thank you, Madam. Rep. Finney? Welcome back, Representative. How you doing?
Fine, thank you.
Oh, very well. Thank you so much for bringing this before us today. Just a quick question. I know that you brought these bills up. Thank you so much for working hard on them. As I told you, I'll support you on them. And I just, in the light of the discussion, is there anything that you would be amenable to or have any thoughts for what we've been discussing on all of these questions that you'd like to see perhaps in an amendment?
Well, one of the things, I don't know how we could do it, but I would like to see each one of those children, even when they come into placement, to be handed a booklet. In addition to having these Bill of Rights, they need to have resources. I mean, something simple. Who do you call? I mean, who do I contact when I am ready to, to leave foster care? Or what is, they say you can talk to each other's supervisors, but nobody knows how to reach those supervisors. Nobody knows how to reach those extra lawyers that are supposed to be there. That little booklet should have some type of resources in it, that they can just easily access and pick up the phone and call, so. And I don't think it'd be very expensive. I'd be willing to donate my campaign funds to get it done.
I would join you in that. And Madam Chair, I would submit to you, is that something that the Oversight Board would do, could do?
Yeah, I just put that on a list of my things to address at our next meeting, so.
All right, thank you. Thank you.
Years ago, when I was doing some volunteer work, and this was like before everybody had a smartphone, but we belonged to an organization that developed a youth yellow pages. And I'm wondering if that couldn't be done for foster care, but it was just a small little booklet, but it had all of those resources that a teen might need, with all the hotline numbers and all the resource numbers and school numbers. Of course, that would change possibly for foster youth, but thank you for bringing that. That's a really great idea, and we'll discuss that. Yeah, thanks. We're going to have all kinds of ideas. Any further questions? Okay. So I'll draw your attention to, there's 4 pieces of written only. Are there any other proponents here wishing to speak? Okay, I show 1 neutral, and that is Thomas Witt with Equality House. Hey, Tom, welcome to committee. Good to see you.
Committee. Tom Witt with Equality Kansas. We advocate for the LGBT population in the state of Kansas. We're neutral on both of these bills today, but I want to point out that 2469, the next bill on the agenda, has a non-discrimination statement in it. That non-discrimination statement should also be in 2468. Of all the people in the youth foster system that are most vulnerable and most need protection, it's the kids. That non-discrimination statement should be in there for the kids. They have no agency, they have no control, and as we heard from an earlier conferee, even 17-year-olds can have problems getting guardian ad litems to listen to them, to hear them. Okay. So a statement about non-discrimination for these kids is critically important. We'd also like to see the non-discrimination statement, if it comes over from the parents' bill that's up next, be amended to include protections for sexual orientation and gender identity, along with the other protected classes. 40% of the kids on the street are LGBT. 30% of the kids in the foster system identify as LGBT. And sometimes those kids get put in homes where the foster families or the group homes do not respect who they are. I know kids that have been, I want to be careful with how I phrase this, but who have been compelled to so-called change their sexual orientation. Our position is, and the position of every reputable medical association in the nation, is that's not possible. And so these kids need the protections from discrimination, and they additionally need the protections from discrimination based on sexual orientation and gender identity. And I hope you'll amend the bill to include that. And I'm happy to stand for questions.
Okay, committee, do we have questions for Mr. Witt? Representative Ousley.
Thank you, Madam Chair, and thank you, Mr. Witt, for being here. So as the only neutral here, could we assume that if the committee did make that change in the House Bill 2468, would Equality Kansas then become a proponent?
Yes, and that is in my written testimony on both bills today. If those changes are made on both bills, then we will be active proponents, and we'll work with the committee and the proponents, the other proponents, to get this passed and to the governor for a signature.
Thank you. Thank you, Madam Chair.
Representative Penn.
Thank you so much, Madam Chair. Mr. Witt, at what age category would these, would the non-discrimination and SOGI pieces that you described, what would be the threshold of that? The question is based off of when is it that when would that become applicable for a child?
Well, I don't think children should face discrimination at any age.
No, that's not my question. When is it apparent to the foster parent that the child would be in need of that particular protection if they're not sexually active or express that they have a gender identity issue or sexually attracted one way or another? If they're 3 years old, 5 years old, or you're talking 14, what is your range?
Well, for every child who becomes aware of their sexual orientation or their gender identity, it's different for every kid. And I think you're asking for a carve-out, an age-based carve-out on two particular characteristics that, frankly, I don't think would be appropriate. I don't think that we should be using non-discrimination language to separate kids.
No, it's not a carve-out that I'm asking, sir. I'm just trying to find out exactly what is the limit of forcing sexuality on kids. If a kid comes into foster care and they're 3 or so.
Let's not put words in my mouth. Nobody's forcing sexuality on anybody. People become aware of their sexual orientation and gender identity on their own. There's no force involved.
I'm not forcing you anything in your mouth. What you said is that I'm asking for a carve-out. That's not what I'm asking. That's a simple question. What's the age?
All children deserve to be protected from discrimination, especially vulnerable kids in the foster youth system.
Okay, thank you. Thank you, Madam Chair.
Further questions? Representative Wagoner.
Yeah, Mr. Witt, the question I have, if we're talking kids from age 0 to 18, that you're making a statement that 30 to 40% of them somehow identify or are actually, gay, lesbian, bisexual. But once you have, isn't that almost an incredible statistic? Because when you're talking about kids 6 and under, 8 and under, 12 and under, I mean, are you serious about your statistical number? That just doesn't compute.
Okay, that's a good question. I appreciate you pointing that out. I should have been a lot more careful with how I phrased that. The kids that were part of the studies and surveys that are cited in the footnotes in my written testimony, and I'd be more than happy to send the PDFs of those to you and to the chair and the rest of the committee if you'd like.
Fair enough. I mean, I would have questions about it, but particularly just given the totality of the foster care population, it obviously didn't make sense.
And you're right. Sloppy on my part. I'll get that study to you if you'd like it. And it is a peer-reviewed study. Okay.
Thank you. Yeah, well, I think everybody would be interested in that. Further questions? Okay, thank you.
Thank you, committee. Thank you, Madam Chair.
Not showing any other neutral, and I do not see any opponents to this bill. Is there anyone here wishing to speak as an opponent? Now's your chance. Okay, then we'll close the hearing on 2468 and open the hearing on 2469, and we'll look to Jesse for an explanation of this bill.
Thank you, Madam Chair. Good afternoon, committee. Again, Jesse with the Reviser of Statutes Office. This second brief of the day is going to be on that House Bill 2469, the next number when you are counting. So this is about the parents. So they are enacting the Kansas Foster Parents Bill of Rights. So House Bill 2469 proposes a Kansas Foster Parents Bill of Rights also be placed in the SYNC code, the revised Kansas Code for Care of Children. And this, it's also got the one section, and it's a new section. It addresses the purpose of the section to be an effort to ensure participation of foster parents in efforts to care for children that are in custody of the Secretary. So in this section, the proposed Bill of Rights for foster parents also has a lengthy list, and some of those items include to be treated with dignity, respect, and trust as a primary provider of care to a child. Here, not to be discriminated against on the basis of religion, race, color, creed, gender, marital status, national origin, age, or physical handicap in state law when it comes against the Kansas Against Discrimination Act, and then also any applicable federal laws. The right to, if the child's values and beliefs are respected, then the parents can continue with their own family values and beliefs, but also taking into consideration the special needs of children who may have experienced trauma or separation in practicing their own family beliefs. Next, making decisions concerning the child, as long as it's consistent with policies and procedures in state and federal law. To receive standardized pre-services trainings by DCF, at appropriate intervals to meet the needs of the children and theirs as they are caring for such child, to receive timely financial reimbursement for the care of the child, and to be notified of any extra costs and or the expenses of caring for such child, receive information regarding services and be able to contact DCF during regular business hours, but then also make sure there's an opportunity to contact DCF after business hours in case of an emergency. They have the right to be notified prior to the placement of the child of any information or issues concerning the child that's known to DCF regarding the care of that child that may jeopardize the health or safety of the foster family. In a way that it may alter the care that family needs to administer in the services they should be provided. The right to discuss known information regarding the child prior to the placement, and with reasonable notice, be able to refuse the placement or request a removal. Receive any information regarding the number of times a child has been placed and the reasons for such placements. To be able to receive the names and phone numbers if those previous placements do authorize that release of information. Receive information relevant to being able to provide the care for that specific child, to provide input and participate in a case planning process, and as well as the planning of visitations that may occur while that child's in that care. Communicate with the child's child welfare case management provider to share and obtain relevant and appropriate information regarding the child and the child's current placement. To communicate with members of the child's professional team. So this includes others who are working with the child, including but not limited to the therapist or physicians or teachers or anyone that is also allowed to share information under state law or federal law. To be notified in advance of any court hearings or reviews of a case planning or a permanency plan of a child, including periodic reviews held by the court in any sort of hearing in the process in the code. the right to be considered when appropriate as a placement option for a child who was formerly with that foster parent, if that child happens to be in the secretary's custody again. And then also to continue contact and communication with the child subsequent to the child's placement from that foster parent's home, but that is subject to the approval of the child and the child's biological parents if the biological parents have not been terminated. They have the right to direct questions relating to their licensure process as a family foster home to DCF and to be able to ask all of those questions about that licensure, and then have the rights described in this section be given full consideration when the DCF develops and approves policies regarding placement and permanency of children with foster parents in a family foster home.
Hey, thanks, Jesse. We have questions regarding the bill. Okay, thank you. Okay, we'll call back Representative Gail Finney.
Chairman Concanon, exactly like the other bill, 2468, this policy has been with DCF for a long time. And in my opinion, I think it's very practical for foster parents to ask for the things that are in these Bill of Rights. But I want to kind of give you some real life examples when they talk about placement and being notified by the courts. For example, I had a youth one time, and they called me like on a Monday and said, could you take this kid? And I'm like, well, could you send me over a referral just so I know what I'm dealing with? They're like, oh, we don't have anything, but we should have it to you by the end of the day. So that was on a Monday, but they did tell me he's been out of school for like, more than 14 days, so you have to get him enrolled in school right away. And so long story short, this kid came to my house at 1 o'clock on a Monday, and I ran to Walmart to get him some shoes. Get him some shoes and some clothes, because I went and got him enrolled in school, got him enrolled in school. He spent the night. Everything was cool, no problems. So the next morning, he had to be at school at 9 a.m. I got him to the school. I went to work. By the time I got to work, I hadn't even got settled. At 10 o'clock, I got a call from the school and said he had tore up the school. They had the police there. Could we come get him? And my husband had to take off work because I couldn't get there soon enough, because I was a substitute teacher at the time. And so I was teaching little kindergarten. I couldn't leave the class right away. So my husband goes there, and the kid had just tore everything down the wall. And they had this huge window where they had all the principals, probably maybe half the size of this wall, or just a casement of pictures. He broke out all the glasses. But I said that to tell you, when we want to know about the youth that are coming into our homes, no one mentioned to me that he had been in the psych facility 2 weeks before they dropped him at my door. I mean, that would have been very vital information to have. And so when you talk about, wanting more information about these placements, you need to know who's in your home, because that kid, he could have been dangerous to my grandkids that are younger, and he had also told my husband if we did bring him back to our house, he was going to tear that MF up. So we're like, we don't want him back at our house. No, please. So we had the police take him to St. Joseph Hospital, and they did well, I couldn't even say they did a screening, because they really couldn't do anything because he was so violent while he was there. I mean, fighting the doctors, fighting police. I mean, long story short, that's a kid that I ended up having to leave at the hospital because we were afraid to take him back into our home. But if I had got that referral information, or if they had been honest with me, I wouldn't have accepted him in my home. But he was just as cool, calm, and collect. But the kid was just angry because he was removed from his home. I understand, because his father had spanked him for whatever, but he was just really, really upset. And so, but finding out ahead of time and knowing something about the history of those children is very, very, very important. I mean, that should be a standard right deep down in our statutes, that, and being notified of like I said, not notified and have the back information on the placements, but also being a part of those case best interest staffing, because you might have a kid that's 6 years old that, you know, you can talk to someone and tell them what the kid likes, what they don't like, and what their triggers are. But if you don't have a voice as a foster parent, they don't even consider your voice, that doesn't get translated or communicated later on down. So being able to have those little minimum rights, I call, you know, being able to participate in some of those hearings on placements, hearing on the courts or, you know, best interest, those things are so important. And I want to kind of give you another example when they talk about basic rights and respect for foster parents. Some of the policies that have been, and some of them are currently being implemented. I had a kid that was just very disruptive in my home, and I was trying to, you know, I had gave my notice for the kid to be, you know, leave, you know. I didn't even have the kid a month and couldn't find out they had a policy in place during COVID that no matter what, you cannot get a kid disrupted out of your home unless you or someone else finds a placement for the kid. So meanwhile, you're stuck with a kid that is violent, that is property destructive. And so to me, that goes back to respect for foster parents, and it makes you want to not be a foster parent. And a lot of you may not know, when a kid tears up your home, foster care, they don't reimburse you a penny. It's on you. I have a friend that had a kid, a teenager, break her 65-inch color television. I mean, it's just on her. So when you become a foster parent, you accept that responsibility and you know that you're not going to be reimbursed for those things. So not being able to have a choice of being aware of some of these children that come in your home, these rights are very important. And I can give you another example of a foster agency I was with. I had a kid one time come just for emergency placement, and the kid was like a $140 a day kid, you know. I didn't know this until after I had an incident with the kid, but the kid was using the restroom on himself. I mean, a big kid, you know, peeing on himself, and long story short, he ended up breaking my dinette set out on my backyard, I mean, on my deck. And so that's when I found out that he was a real high level, which they only paid me $60. I mean, so it's being fair in the treatment of pay. That should have been consistent, you know. So the foster parent, the other foster parent that had the kid come there, he was like apologetic about it. He was like, oh, I didn't know they was only paying you $60. So he gave me another $100 just to replace the tabletop and something like that. So those are kind of like real life incidences and why these foster parents' rights are so important. And another one, this just happened recently, and I think it's with St. Francis, I've heard this, that like one of those ER kids that come to your home, they want you now to provide the transportation for that kid when the kid leaves your home going to the next ER patient. I mean, ER placement. And that it could be anywhere within the state, but they're not offering to pay you. So to me, that goes back to the respect and, you know, not being able to get a kid out your house when they're disruptive. I mean, so I can go on and on about examples of things that I've experienced and I've heard. And that was one of the main reasons that I think these foster parent Bill of Rights, they need to be considered and be a part of Statute 2, in the Statute 2. But it would be nice if they could be enforceable. But I think it would at least open up the eyes for some of these foster care agencies that they need to treat foster parents better, because I believe that a lot of foster parents are getting out of the foster parenting because, like I said, you bear the cost. A lot of times you don't know what you're going to get in the home or what type of characteristics you're going to get. Not saying that's with all kids, but sometimes the chances are that, I mean, someone can actually get hurt, you know, when you don't know these things. And sometimes you don't even know if a kid is coming that may need some serious therapy or that they're even are taking medication. Sometimes you just don't know. But if you're part of the conversation and being able to communicate with people that know, it will make a big difference and, you know, make it much more easier for you to make a loving home for these children if you have the information and you can be able to communicate and be a part of those professional case teams. So that's it in a nutshell, and I ask you to support this bill as well.
Well, thank you for bringing this to our attention. I've just recently heard of a family with a young girl, like 7 or 8 years old, that had been sexually abused, and they had not been informed of that, which, you know, you're talking about needing therapy. Yeah, they want to take special care in that situation. So, but I've had a lot of the stories on the violence in the home too, so setting fires.
Oh, yeah. Okay. And I just want to throw something else out too. When I was calling different foster parents trying to get them to participate, they're like, "Oh no, Gil, I don't want nobody, you know, being vindictive or, you know, it getting back that I said this or I said that, and you know, I don't want nobody retaliating against." A lot of people, they fear their caseworkers, you know, and when they fear their caseworkers, they're just afraid to speak up on a lot of these issues. You know, we might speak to it, and I look our there's several foster parent groups and foster youth groups on Facebook, you know, and they'll chat about these different issues. But when it comes to actually speaking to people that can make a difference in policy and procedures and things like that, they're afraid to do it or come forward because they're afraid that their name might be get out, that, you know, they're testifying or, you know, telling some of the things that are actually happening in foster care.
Yeah, and I have had parents that have talked to me that have been retaliated against. So
I told them, I said, why don't you just submit testimony, just maybe put some initials and put anonymous or something like that, and
yeah,
they weren't willing, so.
it's just hard. You can't question them then. Okay, are there any other questions for Representative Finney? Representative Penn and then Smith.
Madam Chair, it's more of a comment than a question. Rep. Finney, I just want to be on the record thanking you and the myriad other foster parents that we have out there going through all the things that you do just to provide a safe place for so many kids, regardless of where they come from, their situation. Thank you for that. It takes a special heart to have that much love to give to somebody else. And you definitely have my support on this bill. I would also like to say that as a CASA representative from Sedgwick County, I can attest to many of the things that you're saying. Kids that are in need of care, they go through a lot, you know, and we don't always get to see it. But I've been to the court cases, right, when there are cases before the judge, and it takes all of a good 5 minutes after you wait there for 2 hours. And you guys are there doing it day in, day out, and thank you for that. I really, really like the bill. And if there's anything that you think that needs to be made to this as an amendment, if you could please notify us of that so we can get that together too.
Thank you.
Representative Smith.
Thank you, Madam Chair. Whenever a representative from Wichita speaks, I take it with a great deal of respect because what you say you've lived. I was wondering if the two sets of bills would ever clash. When I say that, I mean, I have 7 children of my own, and oftentimes they didn't like what I do or did or corrected or whatever. And as a foster child, I don't want them on the phone calling their counselor every time I do something. And do you see that as a problem at all?
I had a case that a kid that did that too. I mean, that does happen. But you just have to deal with it, you know, because, I mean, actually when you get a chance to talk to the person that they actually called or whatever, sometimes it's because, in this particular case, I was trying to get them to clean up their room. And they just decided they didn't want to do it. So they called their case manager, I want to leave, they're making me clean up my room, you know, and I finally got a chance to talk to them. I was like, yes, I mean, they need to clean their room. I mean, you know, they're old enough where they know, you know, so that does happen. But I don't see that as a conflict. I just think it's an opportunity to communicate with someone else that's, you know, on the team with the kid.
Okay, thank you. Thank you, Madam Chair.
Okay, further Representative Vaughn.
Thank you, Madam Chair. Thank you, Representative, again for your presentation. I was just wondering, is this also something that's in policy and you're hoping to codify or?
Yes, it's already in, it's been in DCF's policy manual for, I don't know how long this one has been there, but I'm thinking at least 2012. But also, I want to mention to you in my testimony, Representative Brenda Landwehr did a very similar bill back in 2002. So we're talking 20 years that we've been trying to get some type of foster parents Bill of Rights going. So, and it's almost identical. It should be identical to what's actually in procedures today.
Great, thank you. Thank you, Madam Chair.
Representative Penn.
Madam Chair, just to add one other thing, I was letting Representative Vaughn know, with the CASA training that we have, both of these bills are completely congruent with the training that we receive. There's nothing new here. This is already what's practiced. So thank you for these bills.
Further questions? Okay, thanks.
Thank you.
Rachel Marsh, Children's Alliance of Kansas.
Hi, thank you for having me again. Rachel Marsh with the Children's Alliance, standing in support of House Bill 2469. I want to highlight a couple areas where we think could be improved and strengthened in this bill. As I think Representative Finney did such a great job explaining the necessity and how it would be helpful, I want to get into the nitty-gritty details of what the language of the bill is. We do have a challenge in recruitment and retention of foster parents, and so supporting them in various ways is a really important piece of us to continue to work towards. So we really appreciate the thought and effort behind this bill. Something that this bill does not have that the previous bill did have, that I think goes back to Representative Wagner's previous question, is a statement at the very beginning that this bill is consistent with the policy of the state in KSA 382201. And in my opinion, that needs to be included because the language of this bill is exactly on the same topics of existing bill in the Child in Need of Care Code, but it is different language. And so different language means more courts and more lawyers and more hearings and more delays. So I would ask for clarification that this bill be read inconsistently with 382201. The next piece that I would raise is that it's entitled a Foster Parent Bill of Rights, but as you know, many of our foster parents are kinship parents, and so we want to make sure, technically, to me, foster parent includes kinship parent, but if we're going to be writing statutes, I think it's important that we're very, very clear that this would include foster and kinship parent rights. Finally, there's a number of pieces of protections for foster parents that are not currently in this bill. Foster parents have the right to present a court report. Foster parents have the right, if they have had a child placed in their home for more than 6 months, to have a presence at the hearing if they choose to ask for a hearing related to move for that child. Foster parents have the right to file a grievance, and in policy, they have a right to the copy of the Bill of Rights. I think I could find more in the current statute, but I did not go through the whole code. So I do think if we're going to do a Bill of Rights for foster parents, that we need to have it be that consistent thing where the rights are encompassed in a comprehensive whole, consistent with the rights that are actually laid out in the code currently, and that we're very clear and precise. The last piece is just a technical amendment. There is a mention of KDHE in this bill a couple of times. KDHE used to be the licensing agency, but is now DCF. So we would need to change that piece in this bill. So again, we stand in support of the bill with those recommendations, and am happy to stand for questions at the appropriate time.
Thank you. We do have questions. Representative Ousley.
Thank you, Madam Chair, and thank you, Ms. Marsh. And thank you for spelling it all out in your testimony, the missing pieces and technical piece. I read ahead to another written-only testimony, and Children's Alliance administers MAP training, right?
Yes, we do.
So this foster parent recommends, if these bills pass, that it become part of the MAP curriculum. And I didn't think that sounded like a bad idea to promote both the bills. So I wanted to get your opinion upon that as we're discussing how to improve the bill.
Sure. We are the kind of owners and operators of the MAP curriculum, Model Approach to Partnerships and Parenting. It is a nationwide foster parent pre-service training, and we would definitely be in support. Our experience is that it provides a partnership with foster parents and agencies, allows a lot of time for reflection and learning and self-evaluation, and to determine whether a foster parent is ready and desiring, after they learn about some of the challenges, to go ahead and be a foster parent. So we would be in support of the model approach.
And I guess it doesn't have anything to do with the House bill so much as maybe just taking it out of the written-only testimony and putting it here for the committee consumption.
Sure.
Thank you. Thank you, Madam Chair.
Representative Wagner.
Thank you, Madam Chairman. Ms. Marsh, thank you very much for your expertise on this. It really is very, very helpful. I guess I have a sort of a practical question. So as much as the system struggles to find foster parents, and I could see them having this would be maybe help their comfort level and be an assistance. I mean, but I also think of a parent coming and, oh, these kids I'm coming, you know, they have their rights, you know, and they have this, that this is going to be kind of like, I mean, I can think of a teenager whose name I won't mention who was always about her rights on this, and it was you know, it does make parenting more difficult if they think it's a question of their rights. And so, do you think the totality of this is going to work out right, as far as in the sense that the system does struggle trying to have, you know, places for the kids to go that are good places? And just
Yeah, thank you so much for that question. I, again, really appreciate that. One of the struggles for me, and I have to tell you that I read this bill with a very skeptical eye, because when you have rights in the foster care system, the rights of the child and the rights of the parent and the rights of the foster parent and others, it's a zero-sum game. When you add rights to one party, whose rights are diminished? So when I read through this bill, I was looking to make sure that there were not places in which someone else's rights would be reduced. And I feel that the bill is written in such a way that the parent, like for instance, consistent with the biological parent's consent or consistent with the best interest of the child. So that was my reading of the bill, with the exceptions of the pieces that I brought up.
Further questions? Okay, thank you. Okay, well, welcome back Mike Fonkert from Kansas Appleseed.
Thank you, Chair Kincannon and members of the committee. Again, Mike Fonkert, Kansas Appleseed Center for Law and Justice, coming to you in support of House Bill 2469. I'm going to essentially echo a lot of my comments from my last testimony. Really support the idea of taking this from policy, enshrining it in statute, and definitely want to highlight our interest in this committee looking at notification and enforcement of these types of provisions. And so our work with foster care parents, foster care children, the Strengthen Families Rebuild Hope Coalition has continuously highlighted from foster parents' perspectives where they feel let down by the system. And I feel like this bill is a step forward on making sure that we do a better job of not letting those parents down. And to respond to some of the previous questions, it would be our belief that enshrining a foster parent Bill of Rights would be a positive as we look to recruit new foster parents to help lessen the burden on the foster parents that are currently in the system. So with that, I would just like to kind of circle back a little bit and point out for the committee, as we do talk about enforcement provisions in our written testimony on House Bill 2468, citation 7 links to an article that does have a lot of discussion about enforcement and things like that. And then a couple provisions that would be worth highlighting or could be examples for this committee. There is a provision in the California Youth Bill of Rights that reads, the child is to be provided with contact information for, and lists out several different agencies related to foster care, such as the Department of Social Services, the State Foster Care Ombudsman, but they're to be provided with that contact information at the time of each placement, and to be able to contact any or all of these offices immediately upon request regarding violations of rights, to speak with representatives of these offices confidentially, and to be free from threats of punishment for making complaints. And so that's just one provision that currently exists in another state around how this could be beefed up a little bit. And there's also some legislation in Nebraska that has a lot of language that I think would be interesting for this committee, and we'd be happy to send that along for the committee's consideration as well. But definitely strongly support the idea of taking this step to enshrine these in statute, and encourage the committee to really listen to stakeholders here and do the best they can to make these as strong as possible. and happy to answer any questions.
Okay, thank you. Questions? Okay, we're flying now. Okay, that is the, that completes the oral testimony for proponents. There's a couple pieces of written-only testimony, and I don't show any other proponents. Are there anyone else? Is there anyone else here? Okay. Then next up, then we have neutral, and we'll welcome back Tom Witt with Equality House.
Equality, Kansas. Equality House is out over in Westport, west part of town. And yes, I'm back. It's been such a long time. I'm sure you all miss me. Thank you. Thank you, Madam Chair, members of the committee. Tom Witt with Equality Kansas. We are neutral on this bill. We would like to see the non-discrimination statement in the bill get fixed to include sexual orientation and gender identity. LGBT families are leaders in providing foster care and adoption for children who are in need of care. And Representative Wagner, I double-checked my language here. The rate you had me scared. The rate at which LGBT families foster children is 6 times that of non-LGBT families. And I didn't put this in my written testimony, but an interesting thing is LGBT family formation, raising kids, is not uniquely so, but statistically, mostly in the red, so-called red states, Midwestern and Southern states, where family values are part of the culture, a big part of the culture. I mean, it's kind of surprising, given a lot of the hostility towards LGBT rights in some of the more conservative states, that this is where LGBT families raise kids. Anyway, that's all I have. If anybody has any questions, I'm happy to stand.
Questions? Representative Penn.
Thank you, Madam Chair. Mr. Witt, what do you see, if you add that language in here, would there be any conflict with the Family Protection Act that was passed by the legislature, I guess 2018, 2019?
That was 2018?
Before my time, yeah.
I don't know.
That conflicted in any?
I don't know.
I'm sorry?
I don't know the answer to that. Not an attorney. I do drink with attorneys, but I'm not one.
Thank you, sir.
Ditto. Other questions? Okay, thank you.
Thank you, Madam Chair. Thank you, committee.
Oh, Representative Neighbor, not for you, Tom.
I'm sorry, I was looking back through some of the written testimony, and I wondered if I could ask Ms. Marsh a question. It's one question.
It's fine.
Okay.
It's good.
Thank you. 2 minutes? Oh, great. Okay, don't pressure me. There are 2 members among your list in the Children's Alliance of Kansas that have been mentioned in written testimony as not being forthcoming on the policies necessarily as they have been written. Do you think by putting these into statute, maybe they'll become more aware? And because it seems like they've avoided offering information to the foster child and to the parent. And is this one way to hopefully enforce that?
Sure, thank you for that question. I have not reviewed the written testimony, so I'll just speak to what I understand your question to be. I do believe that when we have the rates of turnover that we have, combined with, as you heard Representative Finney mention, some of the very challenging youth that take a lot of time and energy from social workers, it can be a challenge to know everything you need to know as a social worker right up front. And so when you're trying to do your work, you may not realize. So something like a Bill of Rights that would be one coherent whole, like I said, that doesn't require you to review the whole statute book, plus all the federal law about rights, would be something that would be more digestible for a worker. So that's the best I can do, not having reviewed that written testimony.
Thank you very much.
Thank you.
You cap it under 2 minutes. Good job. Yes, Tom? Can you come to the mic? Yeah, come to the mic, please.
Thank you, Madam Chair. Representative Penn had asked a question about what impact would this have on the 2018 bill, and I am reading from that. Section 1A, the provisions of this section shall be known as the Adoption Protection Act. B, notwithstanding any other provisions of state law and to the extent allowed by federal law, no child placement agency shall be required to perform as this council recommend consent to refer or otherwise participate in any placement of a child for foster care or adoption when the proposed placement of such child would violate such agency's sincerely held religious beliefs. So I want to focus on the language notwithstanding any other provision of law. Not being an attorney, my understanding is should you amend 2468 and 2469 today to include discrimination protections for sexual orientation and gender identity, that language would leave the 2018 law intact. That's my understanding, but you should probably talk to people who are smarter than me. Thank you.
Thank you. Yeah, thanks for that clarification. Okay, any other questions? Okay, I'm not showing, that was neutral. I'm not showing any opponents. Is there anyone here to speak as an opponent? Seeing none, I'll close the hearing on House Bill 2469. I had planned on trying to work some bills today, but we have had a busy day, and I feel like there are some amendments that we might be interested in. So with that in mind, tomorrow was scheduled to be on call of the chair. I am going to plan to have a meeting tomorrow, and we will work some bills. Just for a heads up, for your information, we will, I'm not sure that we will work all of these, but the ones that we will take a look at will be Senate Bill 12, Senate Bill 276, Senate Bill 329, and House Bill 2468 and 69. And like I said, we may not work all of those, but those are the ones I'm currently looking at and need to get my ducks in a row before tomorrow. So